on the Consolidated Labour Laws of India, what to expect in financial year 22-23. As we know, the new set of regulations consolidates 44 labour laws under 4 categories of codes, namely Wage Code, Social Security Code, Occupational Safety, Health and Working Conditions Code, and the Industrial Relations Code. What is the status of the 4 labour codes, and what does this mean for our informal, formal, or the organized and unorganized sectors of the workforce in the economy? To make this discussion fruitful, we have with us Mr. Anshul Prakash, partner Ketan & Co., and Mr. Faisal Sherwani, partner L&L Partners. I'm afraid our third panelist, Ms. Neha Nagpal, head of Chambers, NM Law Chambers, is unable to join us owing to COVID. We wish her good health, and on that note, let's get the show on the road. I'm your host, Ashima Uri, managing editor of PW Legal World, along with Krishnendra Joshi, our editorial lead. Together, we hope to get you as many insights from our experts. So experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation. Panelists, could we have a brief precursor to your thoughts on the status of the 4 labour codes? Anshul, coming to you first.
So Ashima, I think a lot of it has been said for the last several years, I have to add, ever since the government at the center took power and they initiated the larger process of consolidation. And I have to say, it is not 44 labor codes, around 29 statutes are going to be consolidated into codes. The important point here is that while substantive law can be frozen to some extent, which you have already seen, because first in 2020, when it came to code on wages, and then we had the other 3 codes having received the presidential assent. But post that, what was really imperative was for the states to also climb the ladder along with the central government and frame their rules under various codes. Now, the draft rules, as we have seen some of them in terms of key industrialized states, they have come up with their draft rules for public consultation. There have been several stakeholder rounds of deliberations also. But if one has to ask when the codes are going to see the light of the day, from a procedural perspective, I don't see much of speed, which ought to have been there. Since 2020, 21, several months have passed. We have seen developments, we have seen reports. But when it comes to something which is essentially frozen for us to read or refer to, that is something which may take more time, because I have been on some of those symposiums and discussion panels with the Union Labour Ministry as well as the Principal Secretary Labour of several states. And what we have generally seen is that stakeholder discussions do involve trade unions. It is ITUC or INTUC. We do have inputs from industry bodies. And then comes a point where there is a conflict. And for several reasons, what we have seen is that the intention was very clear from the beginning, but then the underlying political intent, geopolitical sensitivities, social issues will always come to the forefront. So if you had to ask me what is happening, I think all of us know what has been happening so far. Discussions, deliberations, stakeholders coming in, draft rules being framed. Some of those like Maharashtra, even when it comes to Andhra Pradesh, not all the courts have seen draft rules which have been formulated. So things are still in the work. If we have to say when we will see these courts to become effective from operational viewpoint, maybe some, maybe not all portions will be becoming effective, but we have to probably wait for another few months, maybe 3 to 4 months to see that some of the operative portions will become effective, especially when it comes to code on wages and OSH code.
Right. And Anshul, what's your overall sense of these reforms? Are we headed in the right direction, would you say?
I think I would put it in a 60-30, 60-40 or 70-30 ratio, because consolidation is one part of it. And of course, it becomes easier for the industry to refer to these consolidated codes and look at with certain uniformity. I'll give a quick example of the definitional attributes of wages. Mm-hmm. And that is something which was always a problem for all the practitioners like us, HR professionals, because the definition of wages was all scattered all throughout under several statutes. But now, at least if you look at it, much of uniformity has been achieved. But yes, it is only, if I have to add, a consolidation. Much has to be seen how we are going to really call it as a reform, because what has really happened is they have compiled things together, put it under different chapters in the code, and then we have said that the subject matters have been consolidated into different chapters. But if you have to ask several points like recognizing the need of the industry, don't just look at it from the perspective of a manufacturing establishment. A blue-collared worker or a white-collared employee, how do you really differentiate between who is a workman and who is not? There are several aspects which have been left wanting. Much have been done. In fact, some suggestions have already been there on the anvil, which have been taken on record by the ministry also, but that's where we are. But otherwise, in terms of ease of compliance, I think that point will be covered, but that is something in terms of digitalization, ease of filings, whether it is on a quarterly basis or event trigger basis, all that has been at least the objective which has been shown or the intent which has been demonstrated is to put it in the line of not prosecuting, but I was facilitating compliance. That's something which I can say is a welcome step.
Right. Thank you, Anshul. Faisal, coming to you for your thoughts on the overall scheme of the codes and the status of where we're headed.
So on the status, Ashima, I sort of share the sentiment expressed by Anshul. Now, I was reading a newspaper article back a couple of weeks where there was a suggestion that these codes might be implemented in this financial year or the next. But as Anshul has suggested, it is at best an educated guess. And your educated guess comes from the fact that the Union Labour Minister was making a statement, I think, in December of last year in the Rajya Sabha, where he said that, number of states have framed rules under the codes. And the center is following up with the other states to frame rules for implementing the provisions of the codes. But I recall that the minister did say that in the absence of proper subordinate legislation under the codes, there are practical issues that would be faced, apart from the obvious statutory bars to implementing these codes. And there is good reason for those delays. There are good and bad reasons, both possibly. If you look at it at the end of the day, it is generally said that regulation of labor and industry, it falls under the concurrent list. It's a bit of an oversimplification because you do have entry 55 as a field of legislation in the union list, which seeks to regulate mines and oil field workers. You have entry 61, which exclusively is there in the union list also. That's in the context of industrial disputes with regard to union employees. So there are a host of fields of legislation which fall exclusively within the domain of the union parliament. But to say that it is a concurrent subject is broadly correct, because there are entries relating to pension and social security and welfare benefits, which are, of course, there in the concurrent list. And if you understand, therefore, center-state relations, there can be a number of reasons for sclerosis. If a state does not like a particular provision in the union legislation, it does not take much to throw a monkey wrench into the whole thing. So I think it's all about sitting back and waiting to see when these are implemented. As a disputes lawyer, it is also often less interesting to me as to what the reasons for the delay are. It's either been implemented or it has not been implemented, and that's the perspective from where you view it. So I think that is on the status. On the overall issue of it, and here I would happily defer to, let's say, an expert like Anshul, but as a disputes lawyer, for me, if you look at labor legislation and industrial disputes and inter-se relations between workers and corporates, this has all been an issue which has been a central theme in Indian politics and life and law. To the extent, if you look at it from a historical perspective, you can find debates in the Council of the Governor General of India. From a more romantic perspective, you can find both good and bad Bollywood movies about relations between workers and the Lala in the industry. So the relative, therefore, and this is all with good reason at the end of the day, because banks smack in the middle of the equation, in the Indian Karkhana, in the everyday factory, in the labor plantation, you have the little man. And the legislation, therefore, has this overarching sort of sentiment to protect the little man, who comes often in the Indian context from an agrarian background or a rural background, which is essentially a humble background. And therefore, the big corporate or the sophisticated Lala should not take advantage of this little man is certainly one of the stated, objects of any labor legislation. But equally, as a driver of the economy, it is desirable that industry should be permitted to boom and spread its wings. So therefore, any labor legislation, its success or its worth is to be assessed against its either acute failure or relative success in striking a balance between these competing rights. To that extent, I think these codes do make an effort to strike that balance. And I think we can go into it in a bit more detail. Anshul has touched upon some of it. But I think the heart is in the right place, like Anshul said. How it is implemented and to what extent you see cooperation from the states in the form of subordinate legislation is something that I think we all need to see and wait and watch.
Right. Thank you, Faisal, for setting the context, both of you. Thank you, panelists. We understand the intent and the heart is in the right place, so, and we see some concerns there. Other than that you might have to flag with us. Krish, over to you to get that from our panelists.
Thank you, Ashima. Hi, my question is for Anshul to start with. You briefly touched upon the aspect of uniformity in wages. Now, what are the other key changes in the India's new labor law regime you see going forward? Are we able to declutter the maze that is labor law?
I think it's a very, I would say, loaded question, Krishnendu, because to cover all the points, how some of these aspects have been covered by the labor codes, because there are multiple subjects. And I think Faisal was touching upon industrial disputes, resolution, adjudication, or settlement as a point. And there also, if you look at the industrial relations code, nothing much has really changed in terms of how we are looking at adjudication as a principle. I think mediation as a subject could have been brought in, more expressly, as opposed to simply saying that labor courts will not be there, industrial tribunals will be substituting those adjudicating forums. And also how we are looking at trade union negotiations, because now we have a concept of a negotiating council. If you have a multiplicity of trade unions for a particular establishment, then there are certain percentages which have been mentioned as to how one union can become a negotiating union or sole negotiation agent or sole bargaining agent. I think some of those aspects have been covered. I think they tried to deal with it, to bring it into a more cosmopolitan forum. But sadly, it's not something which can be seen as practically something which will be seen as a very forward-looking approach. But yes, in terms of compliances, I can say if you are able to demonstrate both at the central and state level that digitalization as a process can actually be made effective, then it is going to solve several problems, because one is about the substantive nature of it, but most of the time, the entire industry grapples with the procedural part. The filings which are on annual basis, filings which are on quarterly basis, filings sometimes which are event-based, whether it is from social security perspective or whether it is from even equal remuneration or those minor laws which are meant to be consolidated by the 4 labor codes. So, and in fact, I was just having a discussion with one of the officers at the Union Labour Ministry, and I do understand that even in terms of maintaining a portal, and I'm giving a very practical viewpoint here. We talk about Shram Suvidha, but if you actually go and practically try to deal with those issues in terms of online filing being facilitated, many times you will see that you're getting stuck. There are technical snags. And if I have to tell you from a technical viewpoint, there are tenders which are being floated to bring up that portal up to speed. And even if the codes are implemented or made effective, let's say this year or maybe next year completely, then much of it will be dependent on the technical aspects of it. Apart from that, on the social security, on the occupational safety and health viewpoint, I think if you look at the standing orders, if you look at the schemes which are yet to be framed, most specifically for the gig workers, the gig economy, it has simply been mentioned that there may be a scheme which will be formulated. And as Faisal was already mentioning, the State Union Minister of Labour did mention about not just about codes becoming effective and implemented, it was also about the gig workers, how the schemes are going to be formulated, but we are yet to see how that scheme would really work, how it is going to have those provisions to differentiate between these workers, these gig workers, and the traditional way of how you deal with your regular employees. So instead of covering each and every point here, because several aspects like a fixed term employee, but ensuring that the fixed term employee also receives end of service benefits irrespective of the tenure, discrepancies which may exist between the Social Security Code and the IR Code, which talk about a minimum tenure for the purposes of calculating gratuity, and that is Industrial Relations Code and not Social Security Code. Similarly, if you look at some of the states like Maharashtra, while it has been recognized that you can have fixed term employees or workers on your payroll, but Maharashtra goes a step ahead in the draft rules and says that it is only a particular percentage of fixed term employees whom you can have on your payroll. So there are several aspects which we have to see how the conflicts are eventually going to be resolved. And more importantly, not just about the labor codes, you have pre-existing shops and commercial establishment statutes, which carry out or which set out the same terms and conditions of service. We are talking about overtime, we are talking about work hours, etc., etc. Now, how do you really ensure that the conflict which is there at the state level and which has been customarily and traditionally followed is ultimately going to be assimilated by the labor codes? Because if you look at the labor codes and the repeal provision, the intention is not to repeal or completely substitute those laws. Those laws may continue to exist. There may be some additions, substitutions which may transpire. But what we need to see is that ultimately the old regime needs to be completely phased out. But that is going to take time. So there may be a conflict of even on the procedural points, forms, etc. I'm talking about the base level. So those aspects, if I have to highlight, are there when it comes to the proposed regime on the anvil.
And as a follow-up question, how would you rate the code in terms of a ease of doing business perspective? And what mistakes do you see companies making on the other side of the spectrum?
No, I think first of all, to rate a regime when it is not even in order of it being effective, I can only say the intent is there. Obviously, echoing what Faisal just mentioned, it's been done with the right heart. The heart is there at the right place. The intention is all there. But I don't know. I mean, I cannot rate it unless and until we really see how the government, and especially when we talk about the facilitators, are coming on board and facilitating and not prosecuting the industry for non-compliances. Needless to mention, we have our self-rectification process. There is a compounding process also which has been introduced. But all of it needs to be seen, because ultimately it's not just about the law on paper, Krishnendu. Probably I'm going to echo the industry sentiment here. It's the intent, it's the mindset, and probably the Babu mindset, the inspector mindset, and transitioning it to the facilitator mindset. Because at the state level also, you have the laws which have designated the inspectors as inspector cum facilitators. And it was at one point in time meant to be only facilitators. But then again, inspector was added. So if you look at it, the controlling perspective from the government side still remains. They want to control, they want to inspect. So to that extent, if you see how it is going to ultimately pan out from a procedural, practical viewpoint, and of course, if you look at the Labor Commissioner's office, I mean, anybody who is an HR professional or a labor lawyer can vouch for it. If you just go and enter that office, it's a conundrum. You're not able to even understand whom to talk to. There is no specific timeline. Of course, in the law, it says 45 days, and then you can approach the tribunal or the court. But it just goes on and on forever. Simply saying that we are trying to mediate and try to arrive at a settlement because for an industrial dispute, the approach is that the moment there is a complaint, I get into the prosecuting mode because I do, instead of saying that I'm giving an opportunity to the other side to demonstrate compliance, I assume there is non-compliance. So that mindset, if it is going to change in the coming few years, because the moment you have an age-old regime which is going to be substituted by the new regime, it's not just about the law on paper. We need to see the mindset changing or completely phased out and being replaced by a new one. But that's going to take time. And we need to see how the people at grade 3 and grade 2 level, the officers there are actually onboarded with intent to facilitate and not to prosecute.
And Faisal, your thoughts from intent to implementation, how are we going to travel this distance?
Right. So look, I agree. So our assessment today of how good these labor codes are, if you're making that qualitative assessment, it might be a little premature. It's a little too early in the day because they haven't been implemented. But look, if you look at it from a rather rudimentary perspective, and the rudimentary perspective is that the Indian law on labor and industry relations and all of that has been a Molotov cocktail of complexities, right? So you have some 40 odd central legislations, and I might be missing out some here, but equally there are 100 or more state legislations. And in that context, there is an attempt to declutter that. Now, as Anshul did indicate, that there is a high likelihood that some of these laws may still continue to be on the statute book. We'll have to wait and see. But if you look at what it is today, it is all a bit of a dog's breakfast. You have, if you go back in time, it's almost as if you were a trade union or if you were in a particular sector of the economy, and if you had a guardian angel, you were able to get a law passed about yourself. So you will find a specific law about the dock workers. You will find a specific law about motor transport workers. There's one for cinema workers. There's a legislation about beauty and cigar workers, as if there are not other forms of tobacco, right?
They missed out tobacco specifically.
Right. So it was it's because possibly the beauty workers had a good guardian angel somewhere in the government, or let's say in parliament, and the other ones did not. So it is that specificity which sometimes you will find to be lacking in rationality. And therefore, you needed to have this sort of an overwhelming umbrella legislation that takes care of all sorts of workers and at least attempts to bridge those gaps where there is a distinction without a difference. To that extent, I think there is something that needs to be celebrated. And when you have a multiplicity of these legislations, you add a lawyer into the equation further, and you will see that there were all sorts of complications. If the laws could speak for themselves, in the first instance, they would complain about the lawyers, as George Savile had famously said. And one particular aspect of those complications is that while you will see that there are such a plethora of legislation and subordinate legislation on the issue of labor legislation, much of the workers who find themselves today in the unorganized sector were completely unregulated and incapable of getting the benefit of legislation that for no good reason was not extended to them. If you look at data that is available in the public domain as of 2011, if you're a person of statistics, you will find that about 87% of India's workers are in the unorganized sector, to whom, strictly speaking, the laws with regard to our traditional labor legislations will not apply, because that test of an employer-employee relationship possibly does not extend. And in that context, you will find that while you can argue, and that that sort of an argument is available on the face of the legislation, a lot of these people were left without the benefit of legislation, which should apply to them, at least to the extent of social security. So this is a first attempt in time. And if you look at it from 1966, when the first Labor Commission was set up, it's been a long time coming. So ultimately, how it is implemented is quite another aspect. But at least you will not be looking at a scenario where 5 workers out of 6 are completely denied benefits which they should otherwise be getting. That's, I think, the good aspect of these codes, is that it seeks to extend its beneficent provisions at least to contract workers, who are going to now possibly enjoy much the same status as regular workers. Then you have migrant workers who have been brought into the fold. Of course, gig workers and platform workers. As Anshul said, there is a lot of devil in the detail there at the end of the day, because there is what is envisioned is a scheme to which the platform or the aggregator, so to speak, will make a contribution that will be 1 or 2% of his actual turnover. And what and how that will happen is something that remains to be seen. So there is a lot of good there, and a lot of ambiguity is how I would put it. And the ambiguity is on account of the fact that we haven't seen these codes in action, and actions speak larger than words. That's my take on it.
We will touch upon the aspect of gig workers, but let me digress to a very popular question. And I want to ask Anshul, what are your views on the take-home salary debate that is going on? How is it going to change?
I think it's a very important question, Krishnendu, and I think something the misnomer and probably misleading information which has been floating all throughout in the media. Every time we see new financial year impacting the salaries will go up or go down, or take home will be reduced. And there has been a lot of hue and cry in almost all media portals, with reports suggesting that there would be a significant impact on the pay structure of employees. Now, what the courts are stating is that if components expressly excluded from the ambit of wages exceed 50% of the total remuneration paid, then some portion of the expressly excluded components will be notionally added to the wages bucket, so that wages bucket is at least 50% of the remuneration for computation of certain wage links payment. It does not necessarily mean that you have to go and restructure your salary structure for the employees. So, if you look at it, it does not really require any change in the remuneration structure. Now, for example, the wages bucket may continue to be less than 50% of the total remuneration which an employee would receive. What the codes are meaning to achieve is that for certain computations like gratuity, if you look at even from a social security contribution viewpoint, if the total wage bucket is less than 50%, then we have to bring in certain constituents and add it to the 50% bucket. So it is largely to ensure that employees are not denied those benefits, because in the past there have been practices where you limit certain contributions only to the basic and the DA component part of it. So that is the largely the intent of the legislature. It's not that we are going to see the pay structure going to change on a very concrete basis. There may be certain restructuring at the cost to the company level, because gratuity as a liability may tend to increase, given the fact that uniformity of wages definition has been brought in. And it will not be just on the basic and DNS allowance, it will be for the entire salary. And the moment that salary, the wage bucket also goes up and exceeds 50%, you have to compute gratuity at the actual salary or wage. So that brings us into a domain where the gratuity liability may increase. So from that perspective, employers may have to see if at all they are going to do some restructuring, where some of the portions which are ordinarily payable to employees may be brought into the excluded part, such that you maintain it only at the 50% level. But that is having its own nuances. The whole point about changing the salary structure, notifying your employees, especially in the protected or workmen category, about the potential change in the wage structure and how this may be also challenged or be subjected to legal scrutiny. So that's where we are. I don't think the intention was to push the industry to do a remuneration structure change. It was largely to ensure that whether we are talking about leave encashment, notice pay, which are state-driven subjects, and also driving the state governments to the situation where even the state legislature is going to have a uniform approach when it comes to computing your overtime, your total, I would say, eligibility in terms of leave encashment, etc. But we have to see. Right now, it is only limited to gratuity, the subjects which are governed by labor codes at present, but much of it will need to be seen also at the state level. So that's where things. I just wanted to explain on the wages part of it.
And is the PF component going to increase the contribution?
No, so I think even on that front, Krishnendu, I would like to clarify that under the current regime also, there is a wage ceiling which has been prescribed. Now, currently it is 15,000 rupees per month. And for, of course, a member, once a member, remains a member, unless you withdraw and completely cease to be a member under the EPF scheme, the Provident Fund scheme. Now, even if you look at it from the perspective of Social Security Code, there are certain prescribed rates, wage ceilings, which are going to be set out by the central government from time to time. The schemes are going to be either made effective on the similar lines as these existed under the EPF Act, or they may be formulating new scheme and replacing the old one completely. But there will be a threshold, there will be a ceiling. And the moment you are a worker who are within that ceiling, we need to look at it from the perspective of what the wages are. But the moment you exceed that wage ceiling as an employee, then it is obviously between the employer and the employee, or especially on the employer's end, to limit the contribution to that statutory wage ceiling, instead of saying that I'm going to compute Social Security contribution on the entire wages. Because if you bring it into that direction, Krishnendu, you will see that even somebody who is earning 5 lakhs per month, it will be compulsory for you as an employer to contribute at the prescribed rate on that 5 lakhs per month and not on the statutory base ceiling. So the limit is already there. I don't think because of this, your EPF contribution is going to increase. The only issue, and I think it has already been dealt with by the courts in India, the recent one being in 2019, where in the Vivekanand Vidya Mandir judgment, the Supreme Court mentioned very clearly that anything which is ordinarily and universally payable to employees will be considered as part of the wages. The basic wage is not supposed to be seen in alienation. So for employees who are earning salary only up to 15,000 rupees per month currently, or some other threshold which may be prescribed as and when the course will be effective or the scheme will be effective, you need to ensure that you are not just looking at the basic and DA component, which are already a part of the included category, but you are also looking at the overall structure, where you are going to make a cumulative assessment of how much you want to compute within that limit when it comes to the EPF contributions under the Social Security. That's where things will stand unless we see a very high threshold of statutory wage ceiling, which is going to be prescribed by the central government.
Thank you so much, Anshul, for the clarification. Faisal, your thoughts?
Yeah, on the issue of implementation, I would absolutely defer to the understanding which Anshul has. So I've never, in my limited sphere of dealing with labor laws, which is in the disputes domain, gone into the nitty-gritties of how minimum wages are calculated. That is something which is obviously not my bread and butter or my area of interest or cup of tea, so to speak.
Okay, so we'll briefly touch upon the aspect of gig workers. Now, coming back to Anshul, social security has been a concern for the unorganized sector and the gig economy. Now, how do the codes address that? Have they addressed it adequately, or do we need a separate legislation? What are your views on that?
So I think important point here will be that government has indeed attempted to do a balancing act, especially when it comes to the gig workers, because for largely the unorganized sector, we already had a legislation. And if you look at the implementation regime also, it does not really matter, Krishnendu, as to whether you are having employees for 2 days or 3 days. I think the intention of law has been very clear right from the beginning. Whether you have contract workers outsourced to third-party service providers or contractors, or whether you have temporary workers, the EPF Act does not really, even the current regime does not really differentiate. It's all about ensuring that the employees, the workers who belong to the unorganized sector, and the question will be, what exactly is unorganized? We are talking about construction sector. We are talking about even in terms of your entertainment sector. We have employees who are taken in on a daily basis or on a weekly basis. They come in and they go. Now, if that is the perspective, I think the point here will be to bring in appropriate records of all these employees to the forefront to ensure that the coverage from Social Security viewpoint is ensured for them. But when it comes to gig workers, it will be slightly different as a proposition. Now, I just talked about government having a balancing act. Now, on one hand, the government has recognized the gig economy for the first time. If you look at the larger perspective, a few years ago, the Delhi High Court did deal with this issue about gig workers, because the workers approached, knocked the doors of the court, and did talk about them being equated with the regular employees or getting those benefits which ordinarily a regular employee would receive. But then it remained in a limbo. Much of it was still to be dealt with on a more formal basis. There is a petition which is already pending before the Honorable Supreme Court at present. But the focal point here under the Social Security Code is that gig economy, the workers have been recognized and the government has made an effort to define it. Now, some definitional attributes require clarity, like traditional model or traditional way of engaging. Now, what is the traditional way and what is the modern or cosmopolitan way? Nobody knows about it. On the other hand, while recognizing the gig workers, the government does not categorize them as employees of service aggregators, but only envisaging special social security schemes for them, which may be, quote unquote, may be framed by the union government on matters relating to life and disability cover, health and maternity benefits, and contributions will have to be made at certain level or at certain percentage by service aggregators. So my take will be that I may not completely agree or disagree with the approach of the government here, because I have to appreciate why a balancing act has been done by the government vis-a-vis the gig workers. The question of status of gig workers, if you have to ask me as employees of service aggregators or platform owners, cannot be resolved simply because of or by virtue of a statute. That is a very, very, I would say, subjective analysis or assessment which calls for it. And essentially, due to this subjective assessment being required based on the nature of engagement between the service aggregator and gig workers, the degree of control which is exercised by the former over the latter, all these aspects have to be considered. So the only point is about recognition of gig workers, providing them with some degree of social security. But I think call them as employees of a service receiver or service aggregator, that is something which has not been covered. So it's a recognition. There are some benefits, but if you look at it, them being covered in terms of wages, salaries, or commission, or whatever you may call it in terms of allowances, that is something which has not been covered. So the intention is there, but it has been limited to only some part of social security and certain contractual benefits, which were otherwise existing in the form of discretionary mode when it came to the relationship between gig workers and the platform owners and service aggregators.
Right. Thank you, Anshul. Another question there, like you said, there is some ambiguity as to whether they qualify as employees or not. In that regard, contracts still would hold most of their rights and terms. Now, can these be opted out? Would the employers try, the ones contracting these gig workers, try to oust their rights through contracts? Is that something that our gig workers should be careful about?
So, Ashima, that is even currently that's the situation, because much of it is contractually driven. And of course, needless to mention, practical aspect is different from what is there on paper. Because several of even members of the gig economy, the gig workers, who are supposed to be recognized by the Social Security Code as and when becoming effective, the larger perspective of them being categorized as employees has always been kept completely aside, because none, in fact, the entire intention of calling them as gig workers was to ensure that I'm not delving myself into or stepping myself into the shoes of an employer vis-a-vis these workers. I want to have freedom. I want to have a complete, I would say, absolving myself from something which will get into the day-to-day affair for these workers. They're free to go.
Yeah.
They have to go, because if you look at it, practically speaking, the Z's or the S's of service aggregators or food aggregators, they don the uniform every second. They get out of the bike, wear the uniform of the Z, and then they get off and go to another place that is the S, which is printed. So, that exclusivity is not there. It's all contractually driven. But whether it comes to an assured payment, whether we are talking about some commission, the rate cards which are prescribed, practically speaking, for these workers, I think that's where things are, and it has always remained.
Yeah.
Have to see that probably in terms of getting those benefits on a more formal note, gig workers can now impress upon, or I would say impose themselves on the service aggregators to say that we need or we require you to comply.
Right. Thank you, Anshu, for that. And, that may leave room for more disputes. Faisal, coming to you on that. So many aspects on whether how we considered conciliation as a traditional mode of, dispute resolution for the labor force. Now, with the mediation bill coming in and lines blurred between mediation, conciliation, how do you see these codes and the mediation bill, or say the dispute resolution, shaping up? Also, another question, Anshul also mentioned that now we, who can register as a union is going to come out in the courts, formalization of trade unions. Now, with all those things on mind, how do you think the dispute resolution is going to shape up, and what are the kind of disputes you're seeing in the office?
So before I start entering into and attempting to answer your question, the first sort of dispute that you will see, I think your line of questioning is more in the context of a dispute that a worker or an employee may have with his employer. But the most common form of dispute today that we are dealing with, and I'll be careful about answering this, is the litigation that Anshul was talking about. There is a petition in the Supreme Court today, which does, in the first instance, suggest that a gig worker is nothing more than a traditional employee. That is the sentiment which is expressed. I am bang smack in the middle of it for one of the parties on the other end. And I think there is, with good reason, partly I am in respectful agreement with Anshul that you can't seek to pigeonhole these employees into, if you want to call them employees at all, these people who do work through a service aggregator as an employee, for the simple reason that there is a lack of exclusivity. There is, of course, the changing of the shirts, as Anshul mentioned. So, and these sort of disputes have been largely common ever since you saw these aggregators cropping up. You have seen some trade union, some union of the labor, registered, unregistered, trying to say, you give me all of the benefits that I should be entitled to under labor law, the traditional labor laws as they apply. And there is a reason, there is a definition to what an employer-employee relationship is. There are judicial precedents to that, and there is fairly good reason to say that these laws and those precedents should not apply to a relationship of this nature. And you have to pick up historically from context here, because if you look at it, there is an undeniable continuous failure of successive governments to generate sufficient employment for all workers that may be looking for work or may be desirous of work. Therefore, there is an overwhelming reliance on private enterprise. So you fail as government to generate employment in a welfare state, and some private enterprise generates something where there is some amount of relaxation, room in the joints, play in the joints for an individual to operate through your platform to earn some sort of a livelihood. And then have equally the fair share of flexibility to work on some other platform elsewhere and make ends meet. For that, it is extremely unreasonable, in my view, for any state, any union to say that the employer now is a traditional employer and is obligated to ensure that a worker gets all of the benefits which the state has failed to deliver in all of these years. And it is irrespective of political dispensation and inclination, there is a successive failure. So those are the disputes which we are facing as litigators today, particularly where we are seen having to take a stance for a particular aggregator or a platform. And there is good reason to do so. Now, these codes do a good thing in that respect, to the extent that there is a statutory recognition, like Anshul said, to the concept of a gig worker and a platform worker. But equally, there is a statutory recognition that this chap is certainly not your traditional employee or a workman. And my humble suggestion, that's the right sort of inference to draw at the end of the day. You cannot seek to pigeonhole every kind of worker or employee, if you want to call them that, nomenclature is not decisive, into a pigeonhole where private enterprise is stranglehold into a position where it has to make sure that everything in the world is granted to this sort of a platform worker. Now, coming to your direct question of mediation and conciliation, I think there should be no roadblock in the way for those sort of endeavors to be made to resolve disputes. And at the end of the day, whether you put in a particular provision for mediation or conciliation is actually quite extraneous to any consideration of this nature. For instance, in the context of the Commercial Courts Act, you will see that there are specific provisions for mediation, pre-trial mediation, which nobody adheres to. Because at the end of the day, you cannot put two people into a room who do not want to come to some sort of an amicable resolution. So therefore, you creating statutory provisions for amicable resolution, either in the name of mediation or conciliation, is, to my mind as a litigator, less important. It is more important to ensure that a conducive environment is created where, even if there is a lack of a statutory provision, the parties are willing to talk to each other. And conciliation and mediation is an aspect that anybody can adopt for any kind of dispute, irrespective of whether there is a statutory provision that is forced down your throat by the legislature or the elected representatives of our union. So that is my perspective on mediation and conciliation. And more particularly, any form of dispute resolution has to be of a nature where, even if it is a traditional, let's say, form of dispute adjudication, where you have a traditional tribunal, as let's say these codes now seek to put in place. There has been a tribunal for resolution of industrial disputes since times immemorial. These tribunals should themselves be effective enough to resolve disputes without having to lean on traditional or let's say newer forms of mediation and conciliation. Your heavy reliance on mediation and conciliation today is because there is an overarching recognition of the fact that your traditional forums of dispute resolution are an utter failure. And therefore, it sounds like a very sorry suggestion to say that, oh, but you have mediation and conciliation, and as the legislature, we will force it down your throat by making a statutory provision for it. The guys who are sitting in the adjudicatory fora should be just as conducive to resolving disputes in just as amicable a fashion, where possible, as any mediator should or any conciliator should be. That is dispute resolution in the truest sense, if you look at it philosophically and jurisprudentially, to my mind.
Right, Faisal. Some great insights there. Thank you so much for that. As we come to a close of this discussion, let's hear your closing comments, starting with Anshul. Anshul, what is that one key takeaway you would have for our migrant workers or white-collar employees? What is it that they can peel their eyes for in the coming year, and maybe some benefits that they could, look out for?
So again, Ashima, very early stage to really comment on. So first of all, white-collar workers is not a concept which is statutorily recognized. It's all about who's a workman and who's not a workman, or I would say worker, because that's a uniform term which has now been used under the courts. The only thing which I can add here is that for migrant workers, there are some more benefits which have been prescribed, including the travel fares, how they are going to be ultimately covered, because it's a very low threshold which has been prescribed in terms of salary, because we were expecting. But for workers or employees who are coming in from other states and probably again sent back from time to time, especially if they're engaged through third-party service providers, may be getting some substantial changes which they can observe when it comes to their status as a migrant worker. But that has not really undergone too much of change. It's only about the money, which may have increased a bit. So probably they need to see how they can benefit more in terms of approaching the employers when it comes to their travel fares or some of the allowances which have already been prescribed being increased. But otherwise, white-collar employees, nothing changes for them. It's all about what they see in the media. My only humble suggestion will be not to rely on what you see in the newspapers and the websites or news websites, because much of it has not been appropriately assessed. Consolidation does not mean that it is mandatory or necessarily requiring you to be subjected to a change or putting yourself to a detrimental position. So that has not been the intention of this law, and one needs to see and take it easy. If you have to ask me colloquially, just take it easy. There's no need to worry or get worked up on how the entire events are going to eventually unfold on the labor code front.
Right. Thank you, Anshul. Wise words there, not to get influenced by news here and there. Faisal, your closing remarks, please.
Right. So, to begin with, there are some positives there, and how it's going to be implemented, I think it's been pinpointed that we need to wait and see how it is implemented, enforced. That aside, there appear to be some positives. Those positives are obviously the statutory recognition to a whole pool of workers that were otherwise completely not recognized under previous legislations. When you come to the little man, that's a recognition of the fact that the pool is much larger. There are provisions which suggest that there will be larger gender neutrality, in the sense that there are no stops here for women. No work is considered to be hazardous per se, as long as the good sense protections are put in place. That's a positive. If you look at it, it is also important to understand that you can't paint it with the same brush. There was some discussion about comparing these codes to the farm bills, that they were steamrolled in. That's not entirely true. These have been subjected to parliamentary scrutiny. A 31-member parliamentary committee has looked into it, suggested 100 changes, of which 74 were implemented, put into, let's say not implemented, put into language into the codes. So there is a lot to look forward to, and some of it remains to be seen. But if you look at the sunshine of it, you will possibly not see the shadows. And let's see how it goes. And wise words from Anshul, it's a wait and watch game, and no reason to get worked up about. I think that was rather well put.
Right. Thank you, Faisal. Some great, interesting points from our panelists today. Hope you can, if you want, you can tune in again on our website to rewatch this session. Thank you so much all for joining us today. Thank you, Anshul and Faisal, for this insightful session today. Thank you so much for joining.
Absolutely delighted.
Thank you. Pleasure.